Hello, and welcome to Termly's weekly privacy news roundup. My name is Carolyn, and I am the Director of Global Privacy and Data Policy at Termly, and I would like to tell you about the top privacy news stories for this week relevant to your business. France's DPA flagged top alternatives to third-party cookies and highlights rules for appropriate use. France's CNIL published a news article disclosing alternatives to third-party cookies, providing background regarding the end of third-party cookies, what that means, rules for using tracking techniques, and indicating continued special interest and enforcement in this area. If you need more context, CNIL includes a short explanation of the difference between first and third-party cookies, the use of third-party cookies in advertising, why we are talking about the end of third-party cookies, and what alternatives have developed as the shift away from third-party cookies becomes eminent. CNIL includes a disclaimer-style note at the end of the article that use of these tracking technologies warrant special attention from the CNIL, indicating that CNIL will keep a close eye on businesses using these techniques to make sure they implement such techniques in a compliant manner. Alternative techniques discussed include internal cookies and digital fingerprinting, single sign-on, unique identifiers, and ad targeting by cohort. Rules to follow when using these techniques. Don't forget the e-privacy directive. It protects communications of individuals, private communications, and terminal equipment. You must ensure consent is a free and informed choice for the user no matter where the information comes from or the technique used. Ensure users keep control of their data, and think about this from the earliest stages of implementation. Think privacy by design. Remain responsible for the implementation of these techniques. Norway Data Protection Agency and Norway's Consumer Agency want to see changes in proposal for new local cookie legislation. Norway's Data Protection Authority, DPA, and Norway's Consumer Agency submitted a joint consultation response to the Ministry of Local Government and Modernization's proposed new Electronic Communications Act. The act would govern consent requirements for cookies and similar tracking technologies. The joint consultation highlights how difficult and or time-consuming it can be for users to stop this kind of tracking, and at the same time, the personal data collected from these practices makes up a significant portion of the data collected about Norwegians. 2. Emphasizes that the proposed act needs to more clearly specify consent requirements. And 3. Requests the DPA be in charge of all aspects of regulating use of cookie technologies. 850 footballers want to be compensated by data collection firms that have been trading their data over the past 6 years. These athletes are sending a message to the sports industry that the way data collection firms use and share performance data needs to change. They sent letters to 17 data collection firms expressing their belief that their data was improperly used. Going forward, they want to require companies using their performance data to pay an annual fee. The footballers argue that the use of their personal information, for example height, would not be excused in other industries. No formal legal action has been taken, yet. Ireland's Data Protection Authority, the Data Protection Commission, or DPC, will have an increased budget in 2022. The Irish government will be increasing the DPC's budget by 22% in 2022, an additional €4.1, for a total budget of €23.2. DPC Commissioner Helen Dixon indicates this funding is crucial for upcoming increased enforcement by the DPC, particularly in the context of the DPC's role as the EU lead supervised authority for many of the world's largest tech companies. The increased budget will allow the DPC to hire 40 new staff focused on investigation, technology, and legal. The Irish Data Protection Commission endorses Facebook's approach to data protection. The Irish DPC issued a draft decision against Facebook with a proposed fine of €36 million, because Facebook's terms of service did not include sufficient information needed to satisfy GDPR transparency requirements. Facebook takes the position it relies on the performance of a contract legal basis for processing personal information under GDPR by including specifics about their data processing activities in its legal terms. Privacy advocates like Max Schrems find Facebook's approach an attempt to bypass GDPR requirements in an obvious attempt to create a loophole, effectively switching from consent to contract when GDPR went into effect. Schrems is concerned that without regulator intervention, allowing Facebook to take this position opens the door for any company to write about the processing of data into a contract to avoid obtaining consent from data subjects. While the DPC is the lead supervisory authority for Facebook, the GDPR includes mechanisms for EU DPAs to take action if they believe the DPC's actions are insufficient. In this case, the draft decision is expected to reach the European Data Protection Board, EDPB. If it does, the EDPB will review the draft decision, and members could overrule the DPC. Agenda published for the next public meeting for the California Privacy Protection Agency. The next public meeting will be on October 18, 2021. Agenda for the meeting includes introduction of the newly appointed Executive Director, Ashkan Soltani, and updates from the following subcommittees: Startup and Administration, Rulemaking Process, New CPRA Rules, Update of CCPA Rules, and Public Awareness and Guidance. China announced draft regulations for the use of algorithmic recommendation technology. The draft regulations are called the Internet Information Service Algorithmic Recommendation Management Provisions. They contain a series of 30 articles which set out rules for use of such algorithms online and address things like search filtering, personalized recommendations, user rights, and more. They were released following the passage of China's Personal Information Privacy Law and will apply to that law along with 3 other Chinese privacy and security laws. Right now, we do not know if we should expect updated drafts or when these regulations will go into effect. The Cybersecurity Agency of China is tasked with supervision, management, and enforcement. The International Association of Privacy Professionals reviewed the scope and purpose of these new regulations in great depth. Click the link below to read more if you're interested. Amazon is appealing the largest GDPR fine issued to date. Amazon filed the appeal at the Luxembourg Administrative Tribunal, challenging the fine issued in July. Amazon is arguing that there was no data breach or other similar exposure that would justify that penalty, The Federal Trade Commission is primed to discuss Internet service providers' privacy practices. In 2019, the Federal Trade Commission, or FTC, issued orders to 7 Internet service providers to look into their privacy practices. Specifically, the FTC sought to learn more about the type of data collected, if any data is shared, how customers can access, correct, and delete their data, internal policies for the handling of data, and whether the data is aggregated, anonymized, or de-identified. The FTC ultimately looked into 6 of those major ISPs and 3 of their advertising affiliates. On October 21st, the FTC will hold an open meeting to present on the findings of those investigations. Check out Termly's resources to help protect your business. Termly, a global leader in data privacy solutions for businesses.